Scientifically Speaking with me, Tarun Nangia. Today we commence the part 4 of our series titled Justice Suryakant as the Chief Justice of India, Opportunities and Suggestions. You watched the earlier parts and you know some interesting suggestions have come forth. Today we have Justice Rishikesh Roy. As you all know, so I served as judge of the Supreme Court, as a member of the all-important collegium of the Supreme Court that appoints judges and also takes many administrative calls. Also, he served as Chief Justice of the Kerala High Court. Good to see you and your warm demeanor, and look forward to interesting insights. Thank you
Thank
for
you,
your time.
Thank you, Tarun, for having me on the show.
And I have with me Advocate Meet Nayak, who's managing partner of law firm Nayak and Nayak. He joins us from the city of Mumbai, but he has an equal footing at the Supreme Court in Delhi, where he's seen, and if I'm not wrong, even the Delhi High Court these days. Uh, Good to see you, Amit. Thank you for your time.
Thank you for having me. Thank you.
I have with me Advocate Vivek Jain, who practices, in fact, a lot on the financial crime side at the Supreme Court. Sometimes you get to see him in Karnataka as well, and the Delhi High Court. And of course, at many states in the country where we've seen Vivek argue matters. Good to see you, Vivek, and appreciate you joining us. At the outset, let me request Justice Rishikesh Roy. Until recently, you served in the Supreme Court. You had the pleasure of serving alongside Justice Suryakant. You were in the court at the same time. Any opening comments on Justice Suryakant that you would like to make?
Well, Tarun, I've had the great privilege of also sharing bench with Justice Suryakant in the Supreme Court. And one thing I think everybody will say, particularly lawyers who appear day in and day out before his court, that he has a very calm demeanor. Now, this is an essential prerequisite for anybody who is sitting in the bench. But then, as a Chief Justice, besides attending to the cases on your board, you have to have a huge number of other responsibilities which may not be forthcoming to a puisne judge. Now, Justice Suryakant, as the member of the administrative committee in the Punjab and Haryana High Court, where he became a judge at a very, very young age. So he's had a huge, years of administrative experience in his parent High Court. And then he was Chief Justice of the Himachal Pradesh High Court. So he brings forth, with his long tenure in the Supreme Court, vast administrative experience as well. But very often, when we see that, judges who become Chief Justice for, tenure of, barely weeks and months, it's very difficult for him or her to, leave an impact. Now, so far as Justice Suryakant is concerned, I think he's having a tenure of, is it 14 months?
16.
16 months, right. 16 months. So, which is relative to the recent Chief Justices, is a fairly long tenure. So I would expect that he would have certain things already playing in his mind. He was heading the NALSA, as you know, the National Legal Service Authority. He put certain thoughts and also spoke about those thoughts in public domain. So last 20 years as a judge, 2 decades as a judge, he must have had huge number of experiences. For instance, I come from Assam, and then I know it, and I have interacted with Justice Suryakant in the Northeast area, where he has very frequently visited. So those are areas which are not in the mainstream radar of judiciary. But even those areas, I think Justice Suryakant has a very, very fine idea about. So I would hope and expect that he will put some of those ideas and execute them. But amongst the 2 or 3 things that I would expect any Chief Justice to deal with are perhaps the area that we can discuss as we go along. And of course, the ideas that he may have that needs to be also carried forward by his successors. So I would like to suggest to the current Chief Justice, Justice Suryakant, that he can, like a collegium is a member of certain number of judges, so he can have a small committee of all the would-be Chief Justices, because we know who are going to be the next Chief Justices after Suryakant. So he can have a small committee of the Chief Justices who are to take over after him and thereafter him, including Sister Nagaratna, who is going to be the first Lady Chief Justice of the country, so that there is a bit of a continuity in the decisions that he takes and execution of those decisions. I think this is very vital, because otherwise, a certain Chief Justice may have certain ideas and he takes those ideas forward. But if the other incoming Chief Justices are not on board with those ideas, then you don't see any fathomable results. So this continuity is what I would like to emphasize. And as we discuss, I'm sure um, important inputs will come from Mr. Amit Nayak and Mr. Vivek Jain, who has extensive practice in the Supreme Court and various high courts of the country.
Thank you, Justice Roy, for your insights and your comments. We'll go to Advocate Amit Nayak, Managing Partner of Nayak and Nayak, for his opening comment.
Tarun, my first comment really is I saw the swearing-in ceremony, at least which was publicized. I think the humility of the Chief Justice of India in touching the elders' feet and the quality of people that were there in the audience speaks volumes of the Chief Justice of India. I also saw great camaraderie between him and Justice Gawai. And I think that again speaks volumes of the Chief Justice of India. I've had the pleasure and honor of appearing before him. Very, very patient, which is again very rare. And I think that speaks volumes again of the Chief Justice of India. As a counsel who's from outstation, and I come from the commercial capital of the country, I must say that I've seen the Supreme Court over the last 2 decades. I've seen many Chief Justices, I've seen many commercial matters. And I think the 2 or 3 things that resonate also come to mind is that ultimately we are in the last court. What you require is not just justice, but a lot of patience. You must understand that when matters travel up to the Supreme Court, the costs that are involved, even for the most ordinary litigant, are colossally high. And therefore, I think patience is very important. He's got a 16-month tenure. He's got a lot of administrative functions to do. But I think the one thing that I would think is that outstation counsel need a little bit of precedence. And I'll tell you why. It is no more, it is not inexpensive. It is expensive to come Delhi. And trust me and believe you me, when matters are adjourned, it does create a problem. I'm not saying you need to make any special treatment, but I think accommodation for outstation counsel and the costs on those litigations are very, very important. And I think outstation counsels need to be sort of categorized in that fashion, especially when we come from different parts of the country. And I think that's necessary. I'm not saying make any further distinction, but I think that is necessary. And I believe that this Chief Justice most certainly will recognize that. The second is the amount of commercial matters, because again, I come from the commercial city and I'm a corporate commercial lawyer. I believe that the understanding of commercial law is very, very necessary. And I believe he's got a robust common sense. And therefore, I think commercial matters need to be handled very, very well. I liked what happened in the Supreme Court in the Sudarshan's case, where ultimately a commercial solution was found to a criminal matter as well. I think from an Indian promoter perspective, Tarun, from the Indian business, what is the messaging that the Supreme Court of India needs to give? That it is easy to do business in India, whether it is foreign awards and recognition, whether it is commercial matters. I think the Supreme Court needs to do that messaging. That is very, very important. And last but not the least, I would say that, social media, and I know this is close to his heart because I've seen this in many matters. the menace of social media needs to be set right. We are very privileged that today you have everything on YouTube and everything is witnessed because everything is in the public domain. But I think some serious action needs to be taken on social media and the misuse and the menace of social media. I think this Chief Justice of India, this is a subject close to his heart. At least that's what I believe. And I'm sure he will do a lot. I think striking the balance on freedom of speech is very necessary. And I think this is a time, the 16-month tenure is very, very good. So as I summarize this, Tarun, as my opening remarks, I think his humility is very, very clear in his swearing-in ceremony. I've seen his patience. I believe that outstation councils need a little bit of treatment which allows cost saving also for the litigant. And I think that is very, very critical today. And in commercial matters, whether it is RBI, whether it is SEBI, whether it's pure commercial disputes which go to the Supreme Court, I think a little bit of leeway in terms of finding commercial solutions. Because I must tell you, as the Chief Justice of India, if he's able to look at commercial matters a little differently, and not the David and Goliath fight or not the poor and the rich man, not that every builder, every developer is bad, not that every promoter is bad. I think the stigma of people who are fortunate and well doing should not play on the minds of judges. And I think that's the messaging that the Supreme Court needs to give. This is all that I have to say. And his social media work, I'm sure, will be for us to see. Thank you.
Thank you. Thank you for that opening comment, Amit. I'll go to Advocate Vivek Jain for his opening comment.
Well, thank you, Tarun, for inviting me. So, before we actually go to the suggestions, I think we should also discuss the man who we are talking about. So, I think Justice Suryakant, we are not only welcoming our 53rd Chief Justice, but we are welcoming a very ordinary citizen in the middle of the Constitution. He's actually been from the corridors of Hisar District Court to the High Court, to the Chief Justice of Himachal High Court, to the Judge of Supreme Court, and now the Chief Justice of India. I think the whole host of experience which he has from the ground levels to the upper echelons of the justice, I think this makes him and that puts him in a very comfortable position where he would be able to see through the problems and can actually give a remedial touch to it. Now, obviously, he's come from a very small town, but he's never hidden it. He's actually carried with it that small town tag and actually, converted into an empathy, which we can see from his demeanor in the court. And I have a pleasure of appearing before him multiple times. And one thing, as a young lawyer, like 5 6 years back, also, what the first thing which strikes you when you appear before him is he immediately puts you in a very comfortable mode, as if you are not rushed. Even on a miscellaneous day, the miscellaneous days are famous. And even if you, as a youngster, you were told by your seniors that, see, you have 1 minute or 2 minutes to make your case. But before Suryakant, Justice Suryakant, you have time. If you are making a point, he would allow you to complete that point and at least have you that kind of a hearing. Because I think he understands that for somebody, it's a last court. And without hearing, if you dismiss somebody's case in the last court with no resort, I think that is something which I think Justice Suryakant has understood and mastered. Now, speaking about suggestion, I think the most important thing, which is the elephant in the room, is the pendency. I think that's the most important thing on which any CJI is the head of the institution. So he would be working on. One thing which I would like him to pay attention, and obviously he would obviously have all the reports and all, is the infrastructure. I think more judges and more courtrooms is an obvious thing for actually remedying the arrears. But with more judges and more courtrooms, you need more infrastructure. And in fact, I was going through it. Well, in fact, I'm repeating myself, but that's the same thing which I'd said in the earlier programs we had for the earlier Chief Justice. As per the reports, if you see, there are deficiencies in the space which is provided to the judicial officer. I'm not talking about high courts. I'm not talking about Supreme Courts, because 85% of pendency, around 4 crore cases, are pending in the district court. So we have to actually empower the district courts with that kind of infrastructure. And the report says that 37% of judicial officers says that there is a space constraint. 30% of judicial officers say that we don't have Ahmad rooms. So in a criminal court, you need Ahmad room. So I think Justice Suryakant is well poised, and he would have that ground knowledge about about the difficulties which a district court judge would have. And I think from there only, when he speaks about mediation, I think that's the subject which is very closer to him. And that's actually, I think, is a mantra, could become a mantra to actually solve the pendency, because by having mediation, you're actually cutting across all the layers of appeal you have in the Indian system. See, if you file a suit, you have a suit, first appeal, second appeal, and then it goes to the Supreme Court. Now, if you were to do mediation seriously, you cut through all those stages of appeal, and you can just remedy the situation between the parties. And obviously, both parties have to compromise for that. So these are my opening comments, and we'll discuss all these topics in detail when we go forward.
Thank you. Thank you. Now we move to indeed suggestions. Justice Suryakant, as head of NALSA, started the Mediation for Nation campaign, which we discussed a lot. Of course, as the Chief Justice of India, we expect a much larger initiative, in which I think will happen. The issue of pendency of 90,000 cases in Supreme Court, 6 crore pendency, roughly about countrywide. Of course, there are issues of bail matters also reaching the Supreme Court time and again. That then take up a lot of time, because the number of bails pending before Supreme Court is literally huge. There is the issue of environment and the attention to environment that is required. Then also the issue of artificial intelligence. Some people have priorities on listings and registry and demands that people make of in a say mentioning what they have to say. People have demands on all this and more. Any suggestions? I would like to request Justice Roy to come in here and say if there are any 1 or 2 or 3 suggestions that he wants to give on everything from infrastructure to AI to pendency and all these issues.
Well, Tarun, I'm sure the Chief Justice will have his priorities, but as a Chief Justice, as the head of the family of judiciary, you need to have long-term, mid-term, and short-term perspectives. Now, so far the infrastructure issues that have been raised by Vivek Jain, very essential, very relevant, but those could be part of your long-term perspective. Now, so far as commercial litigations that have been spoken of by Amit Nayak, and to give a bit of a priority there, we must understand, as a former judge and also as part of the legal system, that matters, say criminal matters pertaining to statutory involvement of the courts, now those cannot go out of the court system. They have to be resolved within the court system. Whereas commercial litigations, it is possible to address them through other alternate dispute resolution mechanism like arbitration or mediation. So here, Justice Suryakant has been harping on putting the mediation mechanism into a much more robust mode. But for that, you see, all the stakeholders, they must come forward. I mean, say people like Amit Nayak, who is deep into commercial litigation, if they can also come forth with suggestions as to how mediation can also be an effective tool for resolution of commercial disputes. And I know it for a fact that in courts, either in the Supreme Court or in the High Court or the district courts, we are referring the family matters and other domestic issues for mediation. But I know it also for a fact that in Bangalore mediation centers, there are private chambers which are operating. They're dealing with some very high-stake commercial matters and achieving good results. So those examples should be replicated, and people who have been successful in dealing with commercial litigations through the mediation mode, they should be brought on board. Their good practice should be adopted, because we are talking about implementing certain schemes. Now, how those schemes or those mechanisms are achieving success in different arenas, in different jurisdictions, those will have to be brought in. And I'm sure as the CGI, as the head of the family, he can easily collect those informations and then give a push. But finally, on the very same subject, government is the major litigator in the country. We all know that. So government also has to be sincere about trying to address the areas of court, trying to also address commercial litigation where again government is always the one of the big stakeholders. So therefore, they must also have a practical look at how alternate dispute resolution mechanisms can be put in place for resolution of commercial disputes. Commercial disputes, so much money is tied up. The country's progress is dependent on how effectively you are dealing with commercial litigations. How the investors are looking from outside of the India, whether to invest or not, they are looking for whether an assurance that there is a robust mechanism in place in the event of we have to go for disputes. So therefore, these are some of the things I feel Justice Suryakant, as the Chief Justice, as the head of the family, will need to look at in a short term perspective. And long term, of course, the infrastructure and other issues are there.
Thank you. Thank you for highlighting these points. I'll go to Advocate Amit Nayak, Managing Partner, Nayak and Nayak, for his suggestions.
Well, I would say your comment on AI, I think, augmented intelligence is very necessary. I call it augmented because I believe that it is time that there is a balance that is struck because of the pendency of cases. Ultimately, the judges in the Supreme Court work very, very hard. I think they need a lot of support. And I think technology, and I think you need to power tech the Supreme Court in a big way. And I think that balance needs to be struck. So I think would be necessary. Today, there are many vendors internationally and in India, in fact, all very competitive, where I think, there must be a sort of a auction. Sorry, there must be a public auction where ultimately today's the best, service provider must provide AI services to the Supreme Court. And I think that is the necessity because everything is going to change in the next 2 or 3 or 5 years. I think that's a given. Uh, that's one. Second, as I told you, and I thank Justice Roy for saying what he did. I must say again, I have been going to Supreme Court for more than 20 years. I feel it's my court as much as Delhi or Bombay. The only thing I feel is that all of us who are from outside the country need that precedence and that audience. It should not be limited or restricted to some people or only some seniors. My view is that, and I think he can do that. And I think that's the feeling that one carries in his court. Of course, I've had the privilege of working with a lot of people, but even on video conference, even on digital appearance, I think some amount of indulgence is necessary, particularly when you're appearing from different parts of the country. And I'm sure he will do that. I think we need to put some framework in that in place. I would say, lastly, that the bail matters that occupy large boards. I would think also the roster, Tarun, in terms of who are the judges taking what matters, what is the subject, and who's comfortable in what subject. I think that is very necessary. Now, when you have Securities Exchange Board of India matters, which are pure regulatory matters, which is the judge that must take up the matters? Who must take up the IP matters? And I don't think there is any shame in doing that, Tarun. I think time has come when we select judges and the collegium select judges, they do it on their subjective knowledge as well. And I think the time has come to recognize the judges according to their subjective expertise, subject expertise. And I think there's no harm, Tarun, in doing that. Because if a judge is good in white collar, is good in PMLA, then that's a judge who must get that assignment and the roster must do justice to that. Because please understand that by doing that, you're allowing speedy justice and good law to be set in motion. It doesn't mean that other judges can't do it. But I think at least having them on the bench is necessary. Because some people who come from different parts of the country may not have that experience in a commercial matter. Someone may not have experience in criminal matters in the way they ought to have. So I think that balance needs to be struck. And I think as a master of the roster, I think he certainly can do that. That would be my suggestion.
Very, very good point, Amit, because, for example, in arbitral appeals, you need very fine judicial minds who have dealt with these kind of subjects, maybe in their life as a lawyer. It certainly will help, given the complex example, construction arbitrations.
Yes,
it is a lot more complex than it used to be a few years ago, with so many variables. I'll go to Advocate Vivek Jain for his suggestions.
Well, Tarun, as far as Supreme Court is concerned, since I've been practicing here for a long time, I would have few suggestions as far as the Supreme Court functioning is concerned. Now, the heart of Supreme Court, when you talk about SLP, what is SLP? It's special leave to appeal. So the heart of SLP is when you grant leave. After you've granted leave in the SLP, it becomes a criminal appeal or a civil appeal. So it becomes a regular matter. So once you've granted leave, it becomes a regular matter, and therefore, I think regular matters are the meaty chunk, and these are the matters which needs to be disposed of as quickly as possible. Now, earlier, like I'm talking about like 10 years back, 10, 15 years back, we used to have dedicated 2 days. Wednesdays and Thursdays, nothing. You would only have regular matters, and regular matters are disposed of. Now, suddenly, obviously, I would not blame the judges because there are a lot of filings happening. There are after notices matter which also gets listed on the regular days. So I think there has to be clear demarcation as far as the regular matters are concerned. And according to me, and I think this suggestion I've given earlier also, that while granting leave or while actually putting a matter for an after notice arguments, you should have a standardized format in the order itself where you would just put, after asking the parties, you would put the time they would consume to argue the matter. Immediately, that needs to be put in a standardized format in the order itself, that I'm putting your matter on hearing on this date, and this is the time allocated to you for both of you. Now, this would solve a lot of problems. Firstly, it would help parties in condensing their arguments orally and putting a written brief. That's number one. It would also create certainty for the litigants who are waiting for their matters to come, because they can now estimate as to when their matter would come. And it would also help court to actually take control of oral hearings and dispose of more matters. So according to me, that can be done when Supreme Court in their orders in a standardized format itself records that this is the time we would allocate. Obviously, that can't be cast on stone. If it is required, you can give additional 10 minutes, 15 minutes, that we are doing in a constitution matters anyways. So I think that is one thing which can be done as far as after notice matters and the regular matters are concerned. One other thing which I think is which is a feat, I think you have a national judicial data grid for Supreme Court. So there is a website for Supreme Court where it actually gives you an insight of what all matters are pending, like civil cases, how many matters are there, criminal matters, how many were there. So I think with the advent of technology and I think if this kind of a data driven analysis of a court system is made for every district at a high court level, I think that would actually help you focus on the points on which grounds or various places where you need to pay concentration to. Because I was actually seeing this website, so I actually got to know that there are 15,000 cases pending in Supreme Court, which are 3 years to 10 years old. So we need to we have realized about this because there is a data analysis of the pendency. So I think if that can be done using the I think that is one thing which I think Justice Suryakant can look into. And as far as AI is concerned, we all know AI obviously can be a force multiplier as far as the infrastructure is concerned. I think it is a force multiplier in infrastructure, but it can't actually take place. It can't convict and can't summon. It can only, you can only search through it. You can actually schedule, translate, transcribe through AI. So I think we have to make use of, as Amit said, we have to make use of AI to its fullest. And we should actually, Supreme Court is already doing it. My focus would be, because you have pendency in the district court, 4 crore cases. I think we should concentrate on arming district judiciary with the AI.
Thank you for those suggestions and the district judiciary and AI. Now we move to the final aspect. One needs to be capable but incredibly fortunate and lucky to achieve the position of the Chief Justice of India. It is a very challenging assignment. It is not an easy crown to wear. So we move on to a round where we give good wishes, and we end the show. We'll start with Advocate Amit Naik, Managing Partner Naik. And any good wishes for Justice Suryakant for his tenure? You've given so many suggestions.
You want me to go first?
Yes.
I would only say that 16 months is a very long time. I would really think that I would only wish him all the luck, but more importantly, all the grace of God, because it is a very difficult chair to hold. You come under a lot of scrutiny and criticism, and today our courts are open. And as the head of the institution, I would only pray that his tenure is successful, which I am certain that it would be.
Thank you. Advocate Vivek Jain, your good wishes for Justice Suryakant.
Well, I wish him all the very best for his tenure, which is considerably a longer tenure as compared to the other Chief Justices. And I think Justice Suryakant realizes it, and he would concentrate on getting justice closer to the poor, and obviously these time frame closer to reality. I think that would be my closing comment.
As I always say in every show, the last word is always belongs to the judge. So we'll go to Justice Rishikesh Roy for the closing comment and the last word on the show.
Well, Justice Suryakant has been, as you know, a very down-to-earth person. But the job of the Chief Justice, it's a crown of thorns. So I would wish Chief Justice Suryakant to age slowly. As he reaches his 65 years, he must not feel that I have aged, 5 years in course of my 16 months. I hope he ages slowly, and he sort of, when he demits office at the end of his 16-month tenure, he must have the satisfaction that I have done my best, and I could, while doing my best, have taken along all the stakeholders, the members of the bar, the employees, the lower judiciary, the people in the district court and at the municipal level, along with me, and achieve something for our great institution, that is the courts of India.
Thank you. Thank you so much for the last word on today's show, where we end our part 4. I would like to thank Justice Rishikesh Roy for his time and gracious presence. Advocate Amit Nayak, Managing Partner, Nayak & Nayak, who joins us from the city of Mumbai. Advocate Vivek Jain for his insights. Appreciate your joining us on this special series titled Justice Suryakant as Chief Justice of India, Opportunities and Suggestions. It was a pleasure having you all. Thank you so much.
Thank you. Thank you.
Thank you. Thank you, Tarun.
Thank you. Thank you.
My co-panelist also.
Thank you. Thank you. Thank you.
For more such videos, subscribe to the Newsx YouTube channel, hit the bell icon.